Court of Appeals, Division 1 is now in session.
Thank you. You may be seated.
Wow. Big map.
Okay, we are here on Division 1, Number 1, CACV 140838, Catalina Foothills Unified School District Number 16 versus La Paloma Property Owners Association, Inc. Council, as you know, we'll allow both sides 20 minutes apiece. The appellant may reserve any amount of time you would like to use in reply. If you do, though, you're in charge of keeping track of your own time. The clock on the podium reflects the total amount of time you have remaining, including what you may have decided to reserve. We have read the briefs, we've reviewed the record, we've discussed the case in conference. I assume that the photos in front of each of us have been shown to both sides and are no objections raised by either side to us seeing them, right? Right? Okay, thank you.
I hope not. I just looked at it.
That would be, it's a good thing then. All right. So, Mr. Schubert, you may proceed. Oh, you know what? I forgot to say, we're recording the proceedings, so when you approach the podium, if you don't mind reciting your name and the name of your client into our record, I appreciate it. Into the recording, I appreciate it.
Thank you, Your Honor. My name is G. Lawrence Schubart. I'm with the Tucson law firm of Stubbs and Schubart, and I appear on behalf of the La Paloma Property Owners Association. In the limited time that we have, I think my most important function is to ensure that there is no misunderstanding as to any of the salient or important facts, which is why I've taken 3 trial exhibits that are photographs of the subject property, and there are separate copies made for not only opposing counsel but for the court. Block 24, which is the school district's parcel, is a 10.255 acre parcel of land. Although it was platted as part of the La Paloma subdivision, it's not really, obviously not an interior parcel of property. It stands more as a peninsula to the property.
Was that taken by the district in the condemnation proceedings decades ago?
Yes, in 1994, the school district completed the acquisition of the property, which is a very important factor as to why we're here today. La Paloma is a master planned and gated community. The way that a developer ensures controlling access to a subdivision that's bounded by major public arterials is by dedicating, as part of the plat, a 1-foot no-access easement, thus surrounding each parcel where it's adjacent to a public right-of-way. There is a platted, depicted, and recorded 1-foot no-access easement. In 1992, the school district decided it wanted to acquire Block 24, but it did not want to be part of the La Paloma subdivision. The condemnation case that was filed in 1992 condemned the covenants, conditions, and restrictions, the CC&Rs. It also named Pima County as a party defendant. And in the stipulated judgment that was entered in February 1994, which is part of the record before this court, Pima County agreed that it would allow any and all access to the adjoining Skyline Drive, which is the major arterial along the north part of the property. Additionally, Pima County agreed that it would abandon the excess right-of-way along Skyline Drive in favor of the school district. Obviously, if there's going to be a breach in the 1-foot no-access easement, the most important factor for La Paloma Property Owners Association was the concomitant agreement that the school district would record a 1-foot no-access easement along the east boundary, which is the common area A, that includes the landscaping buffer and the platted road Campo Abierto. That was part of the agreement that was reached in 1994. Now, a problem obviously arose. The school district attempted to repudiate that agreement that was reached in 1994 and there was a separate litigation, the declaratory judgment action, which results in a memorandum decision that's actually very instructive as to some of the issues that are now before the court. Once it was determined that the school district did not have access to the Common Area A and to Campo Abierto, they filed a condemnation action. The initial action that was filed sought to condemn an access easement to Campo Abierto. That case was properly dismissed by the trial court. Obviously, and there's no debate as to the fact that school districts lack the authority to condemn access easements or rights of way. They can condemn, but for one fact only. The legislature limited school districts to the acquisition of property for buildings and grounds. Thus, after the complaint was dismissed, the school district immediately responded by filing a first amended complaint saying, well, what we really want to acquire is Common Area A as part of the buildings and grounds. Well, when you look at our photographs that are in evidence, that gives rise to an immediate issue. If the school district is only using 40% of its property, Exhibit AC is a photograph that's closest in time to the filing of the summons and complaint, which is an important date in condemnation proceedings. That's when you measure damages. If the school district is only utilizing 40% of its property for the early learning center, where is the need nor necessity to acquire additional area to fill out their buildings and grounds?
Well, let's talk about that.
Yes, Your Honor.
Your brief makes the argument that a school district doesn't have the power under 1211 to condemn property for use as access.
That is correct, Your Honor.
But that's not really your argument, is it? Because you didn't, there was no complaint that after the school district acquired Lot 24 that it proceeded to build the road that allowed it access to Skyline.
The school district did, in fact, not only utilize its prerogative to have access to Skyline, which is the major arterial along the north side, but they also received from Pima County, that's evident in Exhibit AC, authority to access Sunrise, which is the major arterial to the south.
So, did the district then, is the premise of my question right, that after having acquired Block 24
Yes, Your Honor.
by condemnation originally in 94, the district then proceeded to use some acreage within that block
For this,
to create access?
not until 2006, but,
But
yes.
it did. So the assumption then is, I mean, it necessarily, under the statute, has the power to use some of property it's obtained by eminent domain for the purpose of access.
Absolutely, Your Honor. And they did do that.
Okay, so
They-
the only question then is whether this particular access is this particular exercise of eminent domain power for the purpose of access is allowed.
Okay. The way I understand your question, Your Honor, is that can a school district access the adjacent public streets as part of its platting and development process? And the answer to that is, of course.
No, my question was whether whether a district having obtained private property by condemnation, such as the district did in 94,
Yes.
can the district then use some of that previously private property to establish access for itself?
Yes, Your Honor.
Okay.
Can I ask sort of a related question? If in 94, is there something that would have prevented the district from acquiring the lot and the street, if they said, if they could show that this amount of land is absolutely essential to accomplish our purpose, and it included that street, would there have been a problem in acquiring it at that point?
There would have been a major problem, Your Honor. And that is the fact that in 1994, it was a friendly acquisition. It wasn't a contested condemnation case. But more importantly, they did not include the individual property owners as party defendants. if the purpose of the school district, which is germane to your question, if the purpose of the school district was to not only acquire Block 24, but to acquire the right to use Campo Abierto, but be exempt from the covenants, conditions, and restrictions, be exempt from paying future assessments, the answer is they would have had to included all the individual property owners that would be adversely affected by that acquisition of their easement right. And
They could do that, and it just makes it for a more
But they didn't do
contested
it.
proceeding.
They didn't do it. And of course, there would have been an entirely different measure of damages. Think about what's happened.
Why would
Because
that
this
have
is-
been different from what's happening now?
Yes, Your Honor. Because in 1994, it was agreed that Pima County would waive the 1-foot no-access easement. That obviates the whole control access process that was contemplated when La Paloma was platted and developed. Because the way you do it is you force people to come in through certain streets by recording the 1-foot no-access easement. When they sought to have Pima County waive the 1-foot no-access easement along the major arterial, basically they would have obviated the whole purpose of a controlled access subdivision. There would have been no need for a guard gate because now there would be access to a public street that could bifurcate or could avoid going through the guard gate because it's contiguous to Campo Abierto. That's why, Your Honor, the agreement reached in 1994 was in exchange for having Pima County agree to waive this dedicated and platted 1-foot no-access easement, the school district will record a 1-foot no-access easement along its east boundary, Campo Abierto. And that was to preserve the integrity of the controlled access way.
And they did that.
It took the declaratory judgment action to compel them to do that, but yes,
It was
that
done.
is effectively done.
It was done.
And that's, in essence, what they want to condemn away vis-a-vis the present condemnation action. But what's so offensive about the present condemnation action is it's not just an effort to restore access. It's not an effort to condemn a 1-foot no-access easement. It's the requirement that they obtain title, fee simple, it's the only thing they can acquire title to a public street, to a private street, excuse me. And that goes beyond the authority, the legislative authority.
Why?
For a whole variety of reasons. First of all, school districts are limited to acquiring buildings and grounds. There's no authority for them, and there's separate statute for cities, state, and counties to acquire streets and rights-of-way and alleys. That's 12-1111 subsection 6.
But you've already conceded that the district had the power, once it acquired Block 24, to establish a roadway access, to use part of the property that it acquired by condemnation for an access way.
And they did do that.
So how is it different? I mean, as I understand the statute, it focuses on the use to which the public entity is going to use the property after it condemns, not the use of the property before. And if we've already established that the district could use some of its condemned property to build an access way as it did, how is that different from using part of Campo, having acquired it, using that for access?
The school district did not come to La Paloma and say, may we access Campo Abierto as an additional means. They condemned it as part of their buildings and grounds, which requires a fee simple acquisition. There are a number of reasons why that's inappropriate and why the La Paloma Property Owners Association is compelled to assert these defenses to that right-of-way acquisition. One of the things in particular, not only Pima County allowing the opening to the public rights-of-way, which could obviate the issues, but the school district, by condemning the Common Area A in fee simple, has usurped the authority of the La Paloma Property Owners Association, which is required to ensure the safe maintenance and use of the common areas. The design for this access way into Common Area A, which includes access to Campo Abierto, was rejected by the La Paloma Property Owners Association as being unsafe in design. They asked them to go back and redesign it. Instead, they filed the condemnation action, got the order for immediate possession, and billed it as they chose to do so. They've usurped that authority from the Property Owners Association, and as a result, there have been 5 accidents in an area where never before an accident had occurred.
But the association was offered evidence at trial of the cost to adjust the conditions as it saw fit, and the jury awarded those damages.
There is a cost to cure valuation analysis that will require the Property Owners Association to do off-site improvements, remove landscaping, and increase site visibility to overcome the adverse effect of that 4-way intersection in an area where no intersection had before been contemplated.
Did the property owners object to the jury instruction on cure, on the obligation to cure, or the obligation to behave reasonably?
No, Your Honor. One of the other problems that is not being addressed is the fact that we haven't yet seen the full burden of the traffic generation by the school district. It's evident from the photographs and common sense that they're only using now 40% of their property. But inevitably, the balance of that property will be utilized. There will be additional traffic generation onto Campo Abierto. There will be additional problems that are yet to be resolved.
Is there any evidence in the record as to which access to the learning center, the school area, is used most frequently? Do half the cars come off Skyline, half of them off somewhere else?
There's no discussion as to that effect, Your Honor. I think one could make certain logical guesses, but no, there's no evidence to that effect.
It looks to me, if I'm following your argument and the history and these pictures correctly, it looks to me like the guard shack is already, or a guard shack is already here in May '05.
That guard shack has been there as part of the original development of the property.
But I'm not clear about this road that appears to be open without a guard shack. Maybe that's a different part of the property.
That is a different part of the property. And that also, where you're pointing, is one of the state's parcels, which is another issue in this case. The state of Arizona has never consented to this acquisition, even though it was represented to the trial court that the state would file a disclaimer or a consent. They have never done so. One of the issues we've raised is the failure to join necessary and indispensable parties. The trial court took the position that the La Paloma Property Owners Association, the master association, represented all the individual interests. Well, if that's true, we've asserted on behalf of the owner of Block 24, the state of Arizona, the impropriety of this matter proceeding forward. Nobody wants to say that we have the right to say that on behalf of the state, yet at the same token, they want to say that they don't need to join the indispensable parties, the lot owners, who have the easement rights to Campo Abierto.
What's the defense that the state would have to the condemnation?
That they are exempt from condemnation. School districts do not have authority to condemn state-owned property or the easements or rights that inure to their benefit. They've never done to it.
Maybe we're getting far afield. I'm guessing we probably are. But if the state has this parcel, if I'm following you correctly.
Yes, Your Honor.
What does that have to do with the school's property over here?
Because the school district has acquired the south 220 feet of Common Area A, which includes Campo Abierto, in fee simple as part of their buildings and grounds.
Okay, they own the road now.
Yes. Well, then
Unless you win on appeal.
Yes. Your question presupposes that a fee simple acquisition allows the school district at the same time to say that acquisition in fee simple is subject to all the rights of the adjoining property owner. And that's the most frustrating part of this whole case. If the school district is required to acquire the property in fee simple, then they can't at the same time be saying, but the adjoining property owners have the same rights they've always had. Everybody has the same right of access they've always had. That's not a fee simple acquisition.
Okay, why can't
And
they,
of course
why
the-
can't they acquire the fee simple and then grant the easement?
Well, because the valuation analysis never contemplated that. The valuation analysis that we were required to do required us to take into consideration the conveyance of an easement. Under our statutory scheme, one has to first acquire the rights, satisfy the judgment, and then pursuant to ARS 12-1126B, only then is the final order of condemnation entered, which would then convey title to the school district. So it can only be that they would convey the easement after the case has been completed.
I'm sorry
But
for interrupting, but did you want to reserve any time?
I only have about 1 minute. Yes, I do, Your Honor.
Okay, thank you.
Have I answered your question, Your Honor?
Yes, thank you.
Thank you.
Good morning. I'm Lisa Ann Smith from Deacon Senior McDonald, Yetwin, and Lacey in Tucson. And along with Diane Miller, I represent the Catalina Foothills Unified School District. Also here with us this morning are the superintendent, Dr. Mary Camerzal, and the assistant superintendent, Dr. Denise Bartlett. Ms. Miller and I are going to be splitting our time. She's going to be arguing about all the condemnation issues, which are really the main issues in this case. I'm just going to speak for a minute about a little bit of the background, address some of the points that Mr. Schubart made, and then address briefly the Title 15 issues that arise in this case that were brought up in his brief. This is essentially the same as the photo you have in front of you, the one that's dated October 2012. And we just thought it would be helpful to get a little piece, a visual of the property. The building that the district has built on Block 24 is an early childhood learning center for students aged 3 to 5, which the district has an obligation under the law to educate these students if they have special needs. And that has to be done in a mainstream setting, so there are tuition-paying students that don't have disabilities who attend the preschool, and then there are the students who have a right to a free, appropriate public education who are educated here. As has been already pointed out, the district obtained the parcel in 1994, but it didn't begin building until 2007. And at that time, when the decision was made that this learning center was going to go here, the district determined that the safest access to the school would include access through the lighted intersection right there at the end of Campo Abierto.
Is that the only traffic signal at any of those intersections?
Yes, it is. And that is why they made that determination, primarily because they were concerned about the intersection there. And there was evidence in the record that there had been some accidents there. The district wanted to provide safe access to its students. So at that time, the district first did approach La Paloma. Mr. Schubart said that they never asked if they could use the road. In fact, the district did believe that it had a right to use Campo Abierto. And they did not intentionally repudiate an agreement that was reached in the earlier condemnation. There was a good faith dispute about what had occurred at that time. In any event, that played out. The court determined the district didn't have a right. But in order to move forward with its planning and with its creating safe access, the district initiated the condemnation action as well. The parcel that is being acquired here is fully contiguous here to the district's current property. And as Judge Johnson, as you already pointed out, the district did build roads through the rest of its property. Mr. Schubart's argued that this access isn't necessary because obviously there's undeveloped property there, but you can see that no other part of that property could get the district to that traffic light.
I didn't follow the division of argument. Are you the one to whom we should direct the statutory questions?
The questions that I was going to address, and I'm ready to turn to them, have to do with whether or not the district acquired the required voter approval for this action.
Okay.
And I can address those very briefly because we do want to save some time. We have a cross appeal, and we wanted to save some time at the end for the rebuttal on the cross appeal. Briefly, the La Palomas argued that the district had to obtain voter approval, which was not the argument that was, at one point he raised before the trial court that we hadn't established that. We showed the bond pamphlet that indicated that the voters had approved using the voters' funds to acquire property, and that this was one of the projects that was approved. Mr. Schubart, or La Paloma, is now arguing that that approval wasn't adequate because it doesn't use the word condemn. It simply says to purchase or to acquire by purchase or lease. But the And he cites some cases. The cases he cites involve entities that do not have statutory authorization to condemn. Here, the district has the statutory authority to condemn, and it merely needed to get its voters to approve its spending their money to acquire property, and the voters did approve that. That legal argument wasn't raised before the trial court, but we did want to address it briefly anyway. He's also arguing, or they are also arguing, that the district can't give the easement to La Paloma without voter approval. And here, all of the authority on the issue about whether or not granting an easement constitutes the sale of property, it all concludes that it does if granting the easement disposes of the property, makes it so that the property can no longer be used for the purpose that the public entity wants to use it for. That simply isn't the case here. It enables the district to use it for exactly the purpose that it sought to use that property for. And with that, I'm going to defer to Ms. Miller for the rest of the argument.
Thank you.
Thank you, Diane Miller, the Office of Diane Miller, co-counsel for the Catalina Foothills Unified School District. And I understand there's a question pending.
I think the question that I'd like to hear you address is, we've got the old cases and the treatises, Nichols and Sutherland, that say that one may imply in a grant of statutory power, the power to condemn for an absolute necessity, must be conferred in express terms or by necessary implication, must arise from a necessity so absolute that without it, the grant itself will be defeated. It seems to me that one might argue with powerfully that a right to use condemned property for access is a necessity. Do those authorities, though, govern a case like this, where the argument is the district has other access to the property, or do those authorities govern in a general, the broader picture about whether the statute allows a school district to use condemned property in general terms for access?
I think, Your Honor, that you're actually making our argument.
Well, I don't mean to. I mean, ask the question.
Well, I think you stated it quite well, actually. I think the older case, well, first of all, there's two grounds, I think, on which this court can find that the district has a right to take in the eminent domain sense. The statute expressly says buildings and grounds. We think, and if you look at the cases that the trial court relied on, all of the cases that they relied on were ones in which the property to be condemned was immediately adjacent and contiguous with the property, so that it made sense in any common sense sort of way that the property being acquired was part of the grounds for that building. And those two are McCulloch and Robbins. And then there's also a third case cited from Mississippi with regard to property immediately adjacent to a penitentiary.
We don't normally think of acquiring an adjacent road as acquiring part of the grounds.
Well, it is part of the grounds. In every school, if you think about it, every school in this state and throughout the country, in fact, the USC case that we cited, the Robbins case, you have internal roadway systems in that school property. That's part of the way you get cars and people from building to building and how people come in and out. So we think it is a common sense part of the actual usage of the grounds is to access the different facilities.
Some of those in the schools I'm quickly thinking of are more like a driveway, though, and this is more of an official street.
Well, it is a private street providing access to different areas within a privately owned community.
But I guess it's not private street if the school district gets to keep it.
Well, the school district is only condemning, and let me back up because I think Lisa Ann touched on this. The school district initially sought to condemn an access easement, and it was La Paloma who insisted, oh no, you must condemn in fee. And we argued against that, and unfortunately, in this case, I think the trial court agreed with La Paloma and said that the district needed to take a fee interest, and that's what we did, because this access is I think, absolutely required and should be allowed by necessary implication, because it is the safest way to access a school, and La Paloma doesn't even disagree with that. In their brief, they concede that this is a safer access point, and we're talking about young children and disabled children in particular. This is the safest access way. I don't think we have a dispute on that.
So you don't need the necessary implication if it's grounds,
I don't think we do.
because that's the sub 6.
Right. I think in this case, it can be considered grounds. It's contiguous all along its border. I think it can be considered grounds.
What if we don't agree? We haven't decided what we're going to do, but what if we don't agree with that, then please make the necessary implication argument.
Well, I think the necessary implication argument is, how do you get to the buildings and grounds? You can condemn for buildings and grounds, but the buildings and grounds are useless.
It seems to me that if a school district or any governmental entity has a parcel and it needs to condemn something in order to access that parcel, that seems to follow the necessary implication. But here, the school district already had two accesses to the parcel. Why is it necessary, so strongly necessary, for a third one?
Well, the testimony was at the hearing that this is safer access, the most safe access, and we're talking in this case for children. And I don't think an argument that, your other access, it might not be as safe, that means you're not allowed to have the safest access or to condemn the safest access really can be justified.
And we have a lot of children who will be crossing on foot.
This is a preschool. There may be people from La Paloma who walk their children to the school. That is possible. But mostly we're considering this as a vehicular, most of the children arrive by car.
Was there any discussion about other ways to improve the safety through other types of access as opposed to just using Campo Alegre?
All the access points possible were considered by both the district and its consulting engineers, as well as Pima County, and there's evidence in the record that the Pima County agreed that this was the safest access way.
Is there evidence that the district asked the county to install traffic signals at either of the other two?
There is discussion that I read from the initial, and the reason we're splitting up the argument is that Ms. Smith was involved with this case from the very beginning, and I was involved for purposes of the condemnation action. But I recall testimony, and she's nodding yes, in the original order for immediate possession hearing, that there were discussions of whether or not the county would allow or put in, because it would be county property, lights along the other streets, and the answer was no.
So that's in the record someplace.
It is.
Getting back to the issue of whether this condemnation should be necessarily implied, the McCullough case that the trial court relied on talked about whether the degree to which the trial court should defer to the condemning entity for its judgment of whether, as I understand the case, I acquire this property or that property, or whether I need to build an auditorium here or whether I need to build an auditorium there. Not so much in the Nichols and Sutherland sense about whether I have the power to condemn property at all to build an auditorium. Do you have a response to that?
I'm not sure that I see as much of a distinction there. Historically and traditionally, courts deferred to the governing body, whatever governing body that was, would defer to their determination of whether or not a condemnation was necessary, there was need for that property, unless there was an arbitrary, capricious, fraudulent conduct alleged, something to that effect. And that's really true today still, even unless you get into the area of redevelopment. For example, the Bailey scenario, where the courts are looking more particularly at the reasoning of whatever the government is in making the decision of necessity.
Okay. What is your response to the argument from the appellant that the state should have been joined as a party?
Well, Your Honor, the state is an owner in La Paloma, just as all of the other property owners in La Paloma are owners. They're all represented by different organizations who are ultimately represented by the umbrella organization, that is the La Paloma Property Owners Association, that was a defendant in this case. And if you review all of the documents in the CC&Rs, some of which were actually admitted in this case, but all of which are in the record at some place, more likely in the order for possession hearing, it was our position that La Paloma represents all of the owners, and that would include the state of Arizona, who owns a block. And the state of Arizona was notified. If they had a concern, I suppose they could sought to be brought in. But there's no evidence in the record that the district couldn't acquire that property from the state of Arizona, because there's no evidence in the record of how that property is held by the state. It's held in a proprietary capacity, for example. Perhaps the rules might be different. There's no evidence in the record as to whether it's trust land, for example, to which different requirements would apply.
Well, so the road that was acquired is common area held by La Paloma for the benefit of the members, which are the other homeowners there's several homeowners associations,
As well
and
as
the interested persons.
as well as the commercial areas which are across Campo Abierto. So the Property Owners Association is an umbrella organization that represents both commercial and residential
And
members.
the state.
And the state,
Is your argument.
yes.
On the question of prejudgment interest, do you have anything to say about the BCI Coca-Cola case and its applicability to interest?
Well, Your Honor, we are down to the point where I was going to defer to Ms. Smith. I'm happy to do so. I'm happy to answer the question.
Do you have any other condemnation questions?
Thank you very much. 4 minutes.
My answer to your question is going to be no. I don't know. I'm not familiar with the case, the BCI case. Our primary argument about prejudgment interest doesn't have to do with whether it should be at A or B of the statute. Our primary argument about the prejudgment interest is that under condemnation law, interest is a part of just compensation. And the case law, of which there's not very much, indicates that it's a judicial function to determine what the appropriate rate of interest is. And in this case, in the published case, Freilich, the court, at that time the statute for condemnation said interest at the legal rate or legal interest. Now it just says interest. Interest shall be awarded on a condemnation award. And so nothing has changed. It's a judicial function to determine. And in looking at it, what Freilich said is, well, here we've got the legislature. It's already set a legal rate of interest. It makes sense. It's a sensible rate. And it's important to have a uniform rate for condemnation actions. So we'll go ahead and use that rate, but it wasn't a requirement. And no, it doesn't say legal interest. It just says interest. And what we do know is that several other condemning authorities, that is covered in the statute, and it says that they'll pay at prime. And so if you look at the judicial theory that the interest rate should be uniform and that it should be part of just compensation and that the court should determine it, it makes sense to use the prime rate. Because if you use something that is far in excess of what that money was worth during the time, which is what the 10% interest rate is, it's a windfall to the landowner. And we know that the law also tells us just compensation is supposed to be just to both the person who is the entity that is condemning as well as those whose property is condemned. So here we have a case where La Paloma's road has been used for 7 or 8 years, but it has had virtually no impact on their ability. I mean, briefly while our driveway was constructed, perhaps. And so it's just to give them compensation in interest for that time, but sticking with the prime rate like the other condemning authorities pay makes more sense. And if you don't,
Although the statute specifies 42-1201 specifies all of the other
I agree.
public entities, but doesn't mention school districts.
I agree.
Normally, we infer that the legislature meant something by that, or it forgot.
Perhaps it could have forgotten. I mean, I think that the thing is what we don't have something to fill the gap. What we have to fall back on is the case law that says that interest has to be determined judicially so that it's part of just compensation. So we're arguing by analogy to the other statute, but I mean, I can't say that it's there hidden in invisible ink because clearly it's not mentioned in the statute.
Mm-hmm.
And if I might save our last minute, I would do so. Okay? Thank you.
Thank you, thank you.
Unfortunately, I have so little time. On March 19, 2008, Judge Miller made the following statement in his minute entry ruling. CFSD acknowledges the state of Arizona could assert an interest in Campo Abierto that would not be subject to condemnation. CFSD expects the state to either formally renounce any interest in the subject property or submit in an agreement to the condemnation action. CFSD acknowledges that any objection by the state could void the order for immediate possession. It can't be both ways. Either we represent the state's interest and we have objected on their behalf, or CFSD has failed to join a necessary and indispensable party. Where the court is headed, I'd like to just address Judge Gimmel's comment. There can be no necessary implication in ARS 12-1111 subsection 6 that also includes school districts. It is expressly limited to states, counties, and cities, the right to acquire rights of way. There are separate statutes in Title 15 that authorize school districts to dedicate part of its land for future rights of way. There are separate statutes in Title 15 that allow school districts to utilize its funds to encourage local government, municipalities, to improve adjoining rights of way. Those statutes show the legislative intent that school districts are not imbibed with the suggested belief that they too can condemn for rights of way. They cannot.
Are you saying under this statutory scheme with the various elements that you've mentioned that there should be no room for condemnation power under a necessary implication?
Yes, Your Honor, I am saying that exactly. And to rule as such would defy the clear guidance given by this division in both Harnish and Orset and all the other cases, Fleming, that have come out of Division 1 that say that this cannot exist by necessary implication. If we have to allude to necessary implication, then the right does not exist. We have the right to assert this property right to reject the school district's acquisition. Think of the bad public policy.
Thank you very much for your argument. You've exceeded your time.
Thank you, Your Honor.
Thank you to both sides. Yes.
They want to do a rebuttal.
Oh, on interest?
I don't know.
Your Honor, he didn't actually, Mr. Schuhart didn't address our cross appeal. Unless you have another question, I don't think it's necessary.
Yeah.
Okay, thank you.
Thanks. Good point.
Sorry.
No. Thank you. We'll take the matter under advisement, and we'll issue a decision in due course. And in the meantime, we will stand in recess for a few moments before our next argument.